Hello and a warm welcome from Frankfurt. My name is Thomas Kors. I'm in charge of financial institutions in the capital markets division of Helaba. I have with me here again Sabrina Mies. Hi Sabrina.
Hi Thomas.
Who is in charge of fixed income research and our senior analyst for covered bonds as well. So everything that we write about covered bonds has to go through our hands, which is the reason why we're doing this webcast again. This is the third in a longer series that is dealing with the status of implementation of the EU covered bond directive. We started out with a general status analysis, then we focused on France versus Germany, and now we're trying to compare Austria versus the previous two jurisdictions. So in this case, Sabrina, let's jump right into this. What's the main idea about the Austrian situation?
But first we have to mention that Austria has 3 laws and they are now merged into one law which is called the Pfandbriefgesetz. So very similar to the German Pfandbriefgesetz. We don't have to think in other ideas here, so same word. And they keep their covered bond types, so the mortgage covered bond, the public sector covered bonds and the ship covered bonds.
So you don't have to worry about fundierte Bankschuldverschreibungen anymore?
That's correct, they are gone, so they're
all
on the street, all Pfandbrief for now. Now let's have a look into the details. What has changed or what is remaining? Maybe very interesting to see that we have now explicit loan-to-value limits here, which hasn't been the case in all the 3 laws before, only in the Hypothekenbankgesetz. Now here the European Directive obviously gives, and the CRR give straight guidance, and we have 60% for the commercial mortgage loans and 80% for the residential mortgage loans. I just want to mention that obviously they are, the Austrian law allows the issuers to come up with voluntary limits, and we see as a market practice at the moment 60% for residential mortgage loans. So that might be the limit that will be there in the future as well. Maybe let's talk about trustee and the administrator. Here the law gives the choice again to the issuer if he's going to appoint an internal or external trustee. But for the administrator, the law is quite clear. As in the past, a cover pool administrator will be appointed, which is called curator in Austria. So that's similar to Germany, actually.
Well, I mean, the general types of assets that we see here are very familiar: residential, commercial mortgages. Anything else that comes up in the new law?
Yes, the Austrian law has decided to include the so-called high qualitative assets, or generic high qualitative assets, which is a proposal of the European Covered Bond Directive. So they have chosen that. I guess it's giving, or they want to have a little bit more flexibility if there are other assets that they like to include into the cover pools.
Do we have a slide on this too?
Yes, I have. Let's go to that. So we know the traditional ones, which we have already seen, and then here on the bottom you can see generic high quality assets, which hasn't been included in the French law, not directly in the German law, although the aircraft covered bonds would fall under this class of high qualitative assets, and now with the Austrians, as we can see, they have included that segment or that asset class here. It's not filled with life at the moment.
And no specific mentioning of aircraft or ships or something like that?
No, not at all. But the directive, the EU directive, is already is providing for rules for that class, which, for example, are that there needs to be a very high qualitative asset right or secure collateral right, such as a mortgage, for example.
Okay. So
needs to be enforceable and so on.
So the usual characteristics that you have to cover. So we won't see student loans or something like that?
No.
Okay.
Not at all.
Good. The next characteristic that usually comes to mind is overcollateralization. So what's the status here?
Well, overcollateralization, in the Hypothekenbankgesetz and in the Pfandbriefgesetz, the Austrian laws had already 2% nominal, not in the fundierte Bankschuldverschreibungen. So now, obviously, they have included the 2% nominal in the new Pfandbriefgesetz for all covered bonds, which is equal to what the Germans did for mortgage and public sector covered bonds. On just include the French here and the German ship and aircraft, which go with a higher 5%. And then on the net present value side, they decided to allow an optional case, so the issuer can decide and include in the statute if they want to go with a net present value calculation. And here the 2% is the minimum OC that needs to be provided for, similar as in Germany, but here it's a rule by law, or it's an obligation by law.
Okay, so the Germans have to use NPV, the French don't have to use it, or actually can't use it, right? Or can they use it?
They can.
No,
the French can't. No, the French can't. No, sorry.
And the Austrians have the choice between whatever they like.
Yeah.
Okay. Now, after OC, the next big item would be liquidity buffers.
Correct. Well, here Austria has chosen to go the same conservative way as Germany. What do I mean by that? Well, you remember that the liquidity buffer covers a certain liquidity need, which is calculated by deducting the maturities and capital, principal and interest by the incoming payments from the assets, interest and principal. So the more maturities you are deducting, the more liquidity need you have, which is not the case if you consider the extended maturities, which will probably then fall due only after 180 days. So your liquidity buffer is reduced, and that is obviously not conservative.
So this approach using the initial maturity is more conservative, safer for the investors, right?
Absolutely, because then in the case, once the issuer defaults, the administrator that comes in has a refinancing period for 18 months, 6 months via the liquidity buffer and 12 months via the extension that he can provide.
So slightly more conservative approach for the Germans and the Austrians than for the French.
Yes, indeed.
Good. And as we mentioned the maturity extensions, the question is who decides if we have a maturity extension? Which are the triggers? Can you tell us a bit about that?
Yeah. Well, first it's interesting to see that while the Germans went by law in terms of maturity extension, so all Pfandbriefe will have the maturity extension element now now the Austrian they allow the choice, or the law allows the issuer to decide on this element. So we will find in the terms and conditions if the issuer has chosen. We have already seen some Austrian issuers coming up with soft bullets in the past, and so we will probably see more as they are now as it's now allowed by law, actually. Similar as for France, actually. So that's very similar here. And now coming to the triggers, which shall be objective. That was the idea of the European Directive. The Austrian law hasn't chosen triggers such as insolvency, resolution, or a breach of the liquidity buffer, while the French law did. The latter is only in combination with the regulator approval. Now they went with a similar way as the Germans did, which is that in the insolvency, the administrator is appointed, and then he has the possibility to extend the maturity if there are a few conditions. And I need to look into my paper because that's if the curator is convinced that the covered bonds can be redeemed at the extended maturity. That's for Austria. And for the Germans, we have 3 conditions which are quite similar, such as that the cover pool is not over-indebted at that point in time, that the extension would result in a solvency of the cover pool, and that it's necessary to avoid the insolvency of the Pfandbrief bank.
So broadly speaking, the triggers and the decision authority as to go for a maturity extension is very similar between Germany and Austria.
Indeed, absolutely, as I would see it. And maybe just to add the extension period, which also can be found in the law, which is 12 months for Austria, similar as to Germany. In France, that will be specified in the terms and conditions.
Maybe at this stage it would help if we look at the overall European picture where the different authorities are in each jurisdiction that decide on this maturity extension. Do we have a slide on that?
Yes, I have a slide on that, and you will see that's quite diverse. So what you can see here in dark blue is if the cover pool or issuer administrator is to decide upon maturity extension, which is the case for Germany and Austria, as you can see, or if the regulator is the one that decides, that's the light blue color here, and you can see that's the case for France. And then we have two other cases which are shown by the other colors.
And this is not to be understood as a valuation of better or worse, it's just a comparison. So we're keeping neutrality here in this respect.
Absolutely.
Okay, thank you very much, Sabrina, for this short update. As I said, this is the third video webcast in our series on the implementation status of the EU Covered Bond Directive. There are more to follow because we have a few more jurisdictions that are setting this in motion right now, or actually have done it already. Sabrina has written extensive research on this as well, which you can find on our website. Here are the details. And of course, the webcasts as such will be available or are already available via YouTube on the Hellerbar channel, or directly by using the links that we can send you. In that respect, well, we thank you very much for tuning in to this webcast again. I hope it was not too boring. We like the topic, of course, but that doesn't make it super interesting for everybody. We wish you to stay healthy, and we hope you keep your thoughts also to our neighbors in the East who are having a terrible time right now. Thank you very much for listening. Thank you very much for viewing. I'm Thomas. This is Sabrina. Thank you.